Okay, got it.
Good evening, everybody. This is Charles Felix. I'm with South Florida Hospital News and Healthcare Report. And this evening, we have our legal webinar with Ben Mirza and group of attorneys within his law firm of the Mirza Healthcare Law Group. And with that, I'm going to right now just really turn it over to Ben. Before I do that, we also want to let you know that we are going to skip a webinar in December because, to be honest with you, it's a little too much for us in December. Lots of stuff going on, lots of parties going on, and you can't party and do a legal seminar at the same time. So anyway, well, maybe you could, but we're not going to. So with that, we'll start back up again in January, and hopefully everybody will have a nice Thanksgiving, great Christmas or Hanukkah, and any other holiday, and also Happy New Year. And with that, I'm going to turn it over to Ben.
Well, thank you, Charles. I guess you and I should have met up back in college. We would have had definitely a good time.
Oh, so God! Oh my God, we would have. There's no question.
Yeah. It would have been unbelievable. But here is today's presentation, and let me begin it. So today's presentation is about avoiding lawsuits from the bedside. So today the first part of it, we're going to talk about actually best practices and what to do in regards to bedside and bedside manners and all that. And then the second part of it, we're going to talk about the liability that arises from that and what to do if something does arise. So I think if you actually are pretty much a lot of physicians don't really understand the second part of this, which is, I think, where the key is for today. You're going to see a lot of really good stuff as to what to do next if things go awry. So as for introductions, my name is Ben Mirza. I am an attorney. I've been practicing for over 20 years. I have several degrees. One of them happens to be a bachelor's of accounting, and I was formerly a CPA before becoming an attorney. And then I went to law school, and I did my LLM of tax law, and I even have a master's of public health or health administration from Yale. And I've worked for large law firms, small law firms. I've worked for large companies and small companies, and I tell you, they're very different, but they're a lot of fun, and they have a lot of unique issues that come up. I focused our practice, on healthcare law for quite some time now. And the person that I'm really excited to talk about, who's actually in the law world as far as healthcare attorneys go, is actually Ed Meyer. He is a celebrity. He is a law celebrity in the healthcare law space. And with that said, Ed, you want to talk a little bit about what your experiences are?
Thank you, Ben. My name is Ed Meyer. I've been practicing healthcare law for 30 years. I am of counsel to Mirza Healthcare Law Partners, and I am licensed in California. I'll make that clear. I'm a California licensed attorney. My background goes back to working initially in Sacramento, California for a small law firm, but I've worked for large healthcare systems, individual small rural hospitals, also representing individual physicians and individual licensed professionals, and most recently with Mednax, which is out of Sunrise, Florida, but handling their Midwest division, operations division. And let me also introduce, very happy to have on this call our associate, Komal Mirza. Komal, will say a little bit about yourself.
Good evening. Thank you for the introduction, Ed. My name is Komal Mirza. I am an attorney with Healthcare Law Partners, and my primary practice area or focus area is in employment law and assisting practitioners navigate their employment contracts, and also assisting them in establishing their practice groups or practice for businesses. And today's presentation should be especially interesting. It's all about your bedside manner and how it can impact possible lawsuits that come your way, or how to avoid lawsuits. And I will try to chime in as we move through this presentation. I was actually in trial for the last 2 days and didn't have a chance to even look at the slideshow yet. So Thank you, Ed and Ben, for taking the lead on this without my assistance. So thank you. And with that being said, please keep in mind that today's presentation is intended to be a general informational educational session only. We will not be providing any form of advice. If you do have a specific concern, please feel free to contact us directly. Our contact information is provided at the end of the presentation. Thank you, and Ben, it's off to you.
All right, as we do in all of our seminars, we always start off with market forces and how businesses are impacted by the money that concerns them. And Ed, you want to talk about this?
Yeah. Actually, it's really interesting. We had talked to Charles about this topic, bedside manners. What's really important, why bedside manners is so important, because those at the bedside are in the front line of potential lawsuits and actually are empowered to actually take actions that can prevent and reduce the risk of potential lawsuits, because those are the people who are in direct contact with the patient. And the patient, some cases down the line might file a professional liability lawsuit for negligence, or a member of the staff might file a hostile work environment lawsuit, again, because those persons that are on the front line and able to really reduce the risk to the hospital, to the physician group, and to individual physicians are those at the bedside. So that's why it's so important to do that. I'll give you an example that I had dealt with years ago, or I know about it. I didn't represent these people. There were someone under my just general operations big, but there was a case where you had a physician group that was the key surgeons in a hospital, and those surgeons were really at the front line of dealing with surgery, but they're also the front line dealing with the hospital staff. The hospital staff being the nurses, and these physicians allegedly, or actually according to the jury, I would say, were sexually harassing in a very horrific way the hospital staff. And at some point, that hospital staff member was complaining about it, and the hospital executive ignored it. And because probably, I don't know why, but mostly could very well have been because they're bringing a lot of revenue in. So the nurse felt that there was nowhere else to go. So she went to her lawyer, filed a lawsuit for hostile work environment. That ended up going to the jury, and the hospital had a sizable, like in a jury verdict in the tens of millions of dollars, because that frontline action, that bedside action, that surgery center action, the surgery operating room activity of the physicians. Now, the hospital ended up having to pay out a significant sum on a jury verdict, and months later, of course, the hospital president, who had ignored these complaints, ended up losing his job. So that's why it's so important to understand the bedside, the frontline nature of reducing risk in lawsuits.
So today our presentation is for 50 minutes. We're about 5 minutes already into it. We're starting off. We're going to be talking about do's and don'ts of the medical practice. We're going to talk about the types of liability and the cases that are involved in these medical malpractice lawsuits, the anatomy of a lawsuit, and then really what to do when a lawsuit actually arises. People wonder, like, what am I supposed to be doing? Well, we're going to lay that out for you step by step as to what you should be thinking about and doing as you go through it. Ed, you want to lead the talk about do's and don'ts?
Yeah. So the do's and don'ts. Now, what we want to talk about do's and don'ts here, because the do's and don'ts are your risk reduction strategies in reducing risk for potential lawsuits, negligence lawsuits, or other types of lawsuits. So in the physician-patient interaction, the physician should obviously be talking with the patient eye-to-eye level. Keep in mind the following. The physician is seeing maybe 20, 25 patients a day. How many days a week are they working? Multiply that by that. How many weeks a year are they multiply that? So they're seeing thousands and thousands of patients. The patient, however, is probably seeing 3 or 4 physicians a year. So their focus level is a lot different than the physician's focus level. The physician might be curt, quick, not really focused because they're going from patient to patient to patient, being rote. But remember that that patient is seeing that physician for, and listening very carefully to all that interaction, is watching all that interaction. And if you have a patient that down the line turns out to be litigious, that patient and is noticing a lot of things that you as a physician or your hospital staff may not be noticing because they're so careful, so repetitive of those interactions. So for example, infection control, are you, what is the infection control activities of your hospital? Is a doctor walking in with a tie? Because ties can be touched, ties can carry infection around. Is a physician providing sufficient information to the patient? Is the physician listening to what the patient has to say to make sure that the outcome of that interaction results in a more positive outcome? Again, talking about infection control, years ago, I was at a hospital, and this is really important now because of COVID. People are very patients. The patient population or potential patient population is very careful about going into hospital because of their concern about COVID. Well, I had a situation, 20 years ago at a hospital where the norovirus went through that hospital, and it was a small community. 10% of the workforce went out because of the norovirus. The local community learned about that, and they started getting a bad reputation. But the hospital dealt directly, very quickly with that situation by putting in very stringent infection control activities that were also very visible to the patient. So when the patients could see that there was someone in the hallway making sure that the physicians and nursing staff walking in and out of patient rooms were disinfecting themselves as they walked in and walked out. That they were not touching doorknobs with their hands, but instead were touching doors with their elbows. All those things that really increase the confidence of the patient in that frontline bedside interaction that gave more confidence in the use of that hospital and infection control. And also, again, down the line, I think the hospital are getting a very high health grades rating for their infection control activities. Also keep in mind that, the team approach, the team approach with the patient. There's that backside conversation, between the physicians, the hospital executives, the nursing staff, to increase professional competence and correct errors or correct activity, make sure people are doing things right. But doing that in front of the patient, that bedside, can actually give the patient an idea that things are not as good as they actually are, or that there's not as much professionalism, or they're not getting the quality of care they should be getting. So it's very important to have a very good game face in front of the patient. When you're handing off patients, transferring care from one provider to the other, that you're saying, oh, here's this person is this licensee, this person's worked here for this many of years, this person has this great specialty, et cetera, et cetera. So you increase the confidence level of the patient, so the patient can really understand that they are having the highest quality of care that your facility is providing. Anything else you want to add there?
Yeah, just another thing is also, do remember that there's actually hierarchy of staff as well, right? So the team approach not only matters in front of the actual patient, and that's one curtain, and then there's other curtains behind the curtain, like, for example, there's like the administrative staff, there is the front desk staff, there is the background medical assistants and nurses. There's a hierarchy there. So share what you share, but share with the appropriate group. Not exactly, sharing everything with everyone, but only with the people that really need, that would affect that particular corrective action. And I think sometimes that can actually lead to like bad, morale and things like that. And it just starts to show in front of a patient. So you got to just watch yourself and how you have a team approach towards taking corrective action, right?
Right. And again, be approachable about problems. the frustration that the patient might have that might lead to the patient filing a lawsuit versus simply complaining to the physician or giving the physician their concerns and the physician then resolving it, or talking to the hospital then resolves it without going through a lawsuit, is whether or not that sort of threshold is whether or not the patient feels that is the physician, is the hospital approachable with regard to a problem that the patient might have. Similarly, the staff, lurking behind all these billing is a potential for a false claim if some billing is incorrect or intention or meets the standards thresholds of a false claim act. And oftentimes that a qui tam plaintiff, a whistleblower goes back to the government and files a lawsuit on a false claim, is they may feel that there's no one to answer. They will answer to it. They have a complaint. They notice something wrong, and they don't feel they could go to the hospital, their staff saying, "Hey, here's a problem. Can we get it fixed?" Instead, they feel that people are not approachable. So it's just so important to be approachable. The doctors be approachable, the staff be approachable, and so that when there is a problem, that problems will be, someone will tell them, "Here's the problem," and they feel that that's going to be resolved.
Another thing to actually look out for is patient history, right? So reviewing patient history ahead of time, just prior to actually meeting the patient, is a big deal. That's where you'll pick up a lot of tidbits from what the other specialists were reporting on a particular patient. You'll pick up tidbits as to the history of what's been occurring with the patient. So it's important to actually take a look at that and incorporate that into your conversation, or that conversation that's occurring at the time, the historical perspective of where the patient has been. And that really, I think, adds to the patient feeling like they're being looked after.
And also take timely notes. Yeah,
taking timely notes. Yeah. But also, taking timely notes is really important, because the more timely you take them, the more accurate they are, right? So, and also be careful of cutting and pasting notes. A lot of people do it. It's a part of the process nowadays. However, it needs to be customized to what actually occurred in the room. And so just make sure that timely notes are taken, so it actually improves your documentation. Because if you notice, like, we're going to hit on documentation even more. The documentation is going to be an important part of what happens later on. So
yeah, and the importance of accuracy of notes is you want to avoid the situation where there is a potential lawsuit. You learn there's a potential lawsuit coming in, and then the medical staff goes back into the notes and tries to make them more accurate, changing things around. Because now, depending on the type of lawsuit, that may be run from simply being a, tampering with potential evidence claim, to if you're actually dealing with potential qui tam violation, where the government is about to ask for notes to actual criminal conduct by changing evidence of a potential, the potential criminal investigation of false billing. So that's why it's so important to timely and accurately and as contemporaneous as possible take those notes. And again, down the line, you feel something might be incorrect, make sure there's an interlineation or a way to see that something had been changed and what the prior one, and then that's being done, as soon as action as possible. But again, we'll talk later about tying down the documentation when there actually is a lawsuit.
If you notice a slide, there's a cartoon on it. The patient has a T-shirt that says, "I hate doctors," and the doctor's saying, "I'm happy to see you too." I think it's important. The point of that, why we put that in there, is because it's kind of important to, although we knock Disney for a lot of things, and you can, it's important to have that Disney-esque approach of always being pleasant, always being open, and always listening and observing and watching the actual customer. So
yeah, so I mean, and this is important too. Is keep in mind what to reduce, potential lawsuits for malpractice, the outcome, you want to have actually the best possible outcome for the patient, right? To have the best possible outcome in that care. The patient knows their body well, right? So when there's a prescription being provided, that especially when you're dealing with very serious diseases, a prescription can have adverse effects. So explain the potential adverse effects so that the patient could look out for that adverse effect, communicate to the physician what that adverse effect something might be occurring, and then the physician can make a professional determination with that information whether that prescription needs to be adjusted or not. But then, if they're not explaining, if the patient is in a void and doesn't understand that this adverse effect they're feeling is related to the medication, then you have that risk of having a poorer outcome from the use of the prescription. So again, it's so important to have that open communication with the patient as they're dealing with prescription drugs that are dealing with very serious medical issues.
I'll talk about this one. The front desk team. The patient experience starts with the front desk team. And I think that's where you want to start with your best foot forward. You want to make sure that the person at the front desk understands and is not just like, somebody who doesn't understand the business. You want to make sure that they're actually the, as they say, the ambassador of the business. Cleveland Clinic actually uses what's called red coats, and the red coats are standing in the lobby with their red coats on, and they're really the ambassadors of like Cleveland Clinic's buildings. So as you walk in, you can ask them pretty much any question, and they'll guide you accordingly. But the thing is, they're almost kind of like the operator in the middle of the whole interaction that's going to help make sure that the patients reach the right destination. Then once that happens from the front desk, then there's also a medical assistant that takes over right afterwards. Then from the medical assistant, there's a handoff over to the physician, and then back from the physician, they're back to the checkout desk, right? So it's got a full circle to it. The patient experience matters. Just make sure that every step along the way, the Disney experience is occurring, and the records are being kept.
Yeah, and that front desk is, again, part of the front line of, understanding whether there's a disgruntled patient, seeing the mail that's coming through, to seeing whether or not there's some certain letters or things coming through that might give tip off that there's someone thinking about a lawsuit and things like that. So, making sure that there's a good communication with the front desk, and that the front desk feels that they can talk with their supervisor and pass on information that is helpful, one, to pay for patient care, and also for protection against litigation. And let me check also about money and copays. Your professional, your managed care contracts will require copays to be collected. Similarly, there may be copays for Medicare, for other governmental programs, and simply waiving those outright, which maybe the front desk thinks it's so nice to do for patient policy interaction. But those, when you start waiving those things that are part of those contractual obligations of the managed care companies and the physician groups who are in the hospital, then that raises a risk of a claim by the plan that there's a violation of the contract. Similarly, in the Medicare world, waiving copays that can give rise to a considered a kickback to the patient to encourage them to come to the facility. So just be very, very careful about that. And we're going to talk too, we don't mention too, but patient threats. I'm going to talk about patient threats of violence, and let Ben talk about patient threats of lawsuits. Sometime down the line, that clinic, that hospital may get a threat of violence against staff members by a patient or a family member of a patient. What not to do the first thing. Do not call the attorney first thing if there's a threat of violence. If there's a threat of violence, flip into if you have a policy on dealing with that, flip into that policy. Generally, call security, call the police. And the police, may respond or they may not respond. They may say get a TRO. But the first thing you want to do is safeguard your staff. keep their staff safe. The law firms can get a TRO, a temporary restraining order against a patient. So that's sort of a secondary thing, but the immediate thing is to keep people safe. You don't want to delay calling the police when there's actual threat of violence because you're on the phone with the attorney on that. So yes, call the attorney down the line or soon
And then,
after, but
uh,
deal
and
first with the issue.
then also, I mean, what I would suggest to you is when a patient threatens a lawsuit, even though it's verbally, I would take it seriously. The only time I've seen actually people threaten lawsuits is when there's a real disagreement on some sort of an issue that they perceive as being substantive. And if that's what's going on in that person's head, I think it's time to really reconsider whether you're the right physician for that person or not. And that's where you've got to really pay a little bit of attention and maybe pick up the phone and talk to an attorney because there's something complex going on, and we're happy to help you with that if the time arises. But yeah, so the next thing that comes into play is actually firing a patient. Ed, how would you go about firing a patient?
Yeah, so you want to have it well documented because the biggest potential litigation issue, or one of the biggest potential litigations, is patient abandonment. So the medical board in Florida, as well as every medical board that I've ever read when they talk about it, is you have to obviously send a letter to the patient, give them time to find another physician, even and provide them some guidance on where they could find an alternative provider. Usually that'll be 30 days at the very least of giving them notice that you're changing care. Continue care of the patient as you can during that 30 days, but give them notice and explain to it. Now, oftentimes you really think you're firing them in the context of a potential litigation. Include your risk management folks in that conversation. Include them so they're clued in that this is what's happening. But firing a patient can be done if you give them time, if you give them an alternative, and you're not abandoning. There's no evidence you're abandoning their care.
Good point. Now, so how do you know, what are the hints of actually a medical malpractice claim, right? So how do you know that you may be getting targeted for that? First of all, there's, like we just discussed, there may be threats from a patient. But the next thing is you might start to get like requests for like medical records or information that the patient is going ahead and collecting ahead of time, maybe even getting prepared to go and talk to a lawyer. And then you might even hear from attorneys that want to meet with the physician or talk with the physician on the phone. So when that starts to happen, you know that something is not quite right. Also, there could be actually complaints filed against the physician's license. And when that happens, when it's filed against a license, some of the complainants are actually preparing for the secondary, which is, a lawsuit. So be careful of those things. Complaints against a physician usually do get investigated. So you really want to be careful of that. Once you get into that sort of a quagmire, you want to make sure you engage outside counsel, make sure that you present your best case and honest scenario to the state. The other thing to actually consider is a letter of intent to sue. So, the state of Florida does require attorneys to issue a letter of intent to sue regarding medical malpractice. So once you see that, that something's coming down the pike. And those are your claims. It's almost like you're getting, people are starting to actually circle and look and find out what's going on. And it's going to feel like that to you. When you start to feel that way, I think that's the time to actually approach risk management and see what risk management can do. If you're an independent practitioner, maybe you call one of us and we'll guide you through it as to what to do. And you just want to make sure that all of your documentation is in play, is set properly.
Yeah, and again, those going back to keep this slide up for one quick second there, Ben. These are all things for your front desk staff to know. That front desk, because they see these things coming through, they need to be communicating them upward. They see a letter come in from with an attorney letterhead on it, and it says a letter of intent to sue. That has to go right up the chain very, very quickly. Against, if they see complaints coming in, if they see requests for medical records that just don't seem just routine, or these other things. That's your front desk could be seeing those things that, the who receive the mail, and they need to communicate that up so you are prepared and knowing that this might be something coming down the pipe and get appropriately prepared to address it.
So the types of lawsuits that can actually come up from bedside manners or lack of bedside manners or things going awry in the background is really failure to respond to a request, failure to respond to a call, failure to even respond to an emergency call. Even though a lot of your messaging systems might say, call 911, it may be that they're going to blame you for what's going on with them because it took about a day or so, day and a half. It wasn't really an emergency to be taken care of within 5 or 10 or 10 or 30 minutes, but it was an emergency that needed to be taken care of within 24 hours. So, they may actually blame you for that. So you got to think about those sorts of things that could pop up. There's also misdiagnosing a lot of times. That could be a possible negligence claim, delay in diagnosing or delay in treatment even, failure to order diagnostic tests, and then also failure to read diagnostic tests and failure to read like those reports that come from the readings of a diagnostic test, right? So, and sometimes there are even like, machine calibration issues that pop up in these tests, but, you got to stay on top of your game as a physician. There's also what's called a failure to refer when it was glaringly obvious that the person was having, let's say, some sort of like kidney issues, you didn't refer them to a nephrologist, or failure to read the notes that were there. Lack of documentation is really what's going to be a big problem if the physician is not paying attention. So documentation. So I'm sure you've heard that before, but again, we can't stress it enough because that's going to be your first line of defense when anything goes wrong. Infections and contamination control is obviously another area of lawsuits. Contaminations from the perspective of, did the hospital food get contaminated with something when the patient was eating it? You can have things like that arise. So do keep those sorts of things in mind and perspective, and you'll be able to steer clear of these. Anything else you guys want to add to this?
Well, no, again, going back to that misdiagnosing thing, that's a question. Often, it could very well be a question is listening to the patient. Did you get the right amount of information? Did the physician get the right amount of information from the patient by focusing on the patient and patient feeling empowered to say very honestly, this is what my conditions are. This is the adverse reactions that I'm having. These are the different things that are out there with regard to my body. That the physician then sees and listens to and factors that in the diagnosis. So it's very important that bedside manner, that bedside interaction gives the physician the sufficient information necessary to appropriately diagnose what's going on, not just the blood tests and the other sort of things that physicians do. I'm not a doctor, but I just want to make sure that there's a factor in diagnosis that is the patient interaction.
And actually, when we as attorneys review contract, we are looking for that, making sure that there's a division. If there is a misdiagnosis due to the actual machines not being calibrated properly versus the readings not being done, we actually try to hedge for those sorts of things within our contracts when we read them and draft them and so forth. So,
Yeah.
now let's say that bedside manners went awry. The patient just, is very disgruntled, and they decide to file a lawsuit. Well, what's going to happen is you're going to get literally a knock, 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 like knock, knock, knock on your door, and there's going to be a process server that shows up. The process server is going to show up either at your business, or if you're named personally, maybe at your home. So when they knock there and they actually deliver that to you, take delivery of it. Don't duck from it, because a lot of people say, well, if I haven't been served, how can they really hold me responsible for something that I was never served? Well, they're gonna get constructive service or process on you, and I've done that on people that I know were ducking me, and because I've just by way of background, I've litigated close to 2,000 cases. and a fair amount of them were complex cases. I've gone after people that really were just owed a lot of money to other people, and it's, so we understand the actual tricks of the trades, and so are the courts. They understand that. So what'll happen after the process server is there's going to be a complaint. The complaint is going to have in it a short and plain statement of facts. And that's really the basis for the lawsuit. It'll tell you roughly what happened, roughly what's going on. And if it's not specific enough, you actually have the ability to require the plaintiff to state the complaint with more specificity. And, there's times that I do that. If I am on the actual defense side, I will actually have the plaintiff state it with specificity, because I want to lock them into the position that they're taking for that time, the period, the occurrence or the event that took place, the facts and circumstances revolving that. I want to lock them into it as much as possible as an attorney for physicians. What you'll also see is on the defendant side, it's typically the physician, their practice group, the hospital. It could even be a nurse. It could even be a lab. It could be a testing facility. Those are typically on the defense side, and they're defendants. And remember, they're all very different parties. Each party is independent. So if you happen to be named as a physician and your practice happens to be named, those are two different entities or individuals that are named defendants. Those are two different defendants. So what I suggest to folks is make sure you get a different attorney for each defendant, because at the end of the day, what's going to happen is everybody's going to do one of these. Okay. And when they do that, meaning they're going to point the finger at the other person, you're going to want to make sure that you're able to do the same. So make sure that you have your own independent counsel. The other thing to expect down the road is, go ahead, any questions?
No, I was going to just make a quick note that one thing to pay attention to is that from the moment you're served with that complaint, you have less than a month to provide a response. So as soon as you're served, you want to make sure that you're contacting your legal team, that you're contacting your risk management team, and getting the ball rolling, because you want to have as much time as possible in drafting that response and taking action as necessary.
Right. And you can actually give yourself more time if you get that letter of intent to sue, because if you get that letter of intent to sue, you know that process and that server is going to come by with a complaint, and y'all, can start that process of getting an attorney, figuring it out, getting prepared before you even get the process and the complaint, getting some of the ducks in the row. Again, given that short time frame to have that initial response, figuring out, hey, a lawsuit's coming, and being prepared.
And just keep in mind that the 20 days that are mentioned here is not business days, it's actual calendar days. So, a lot of people think like the courts operate on this business days system. I do not allow for actually everything in my mind travels in terms of calendar days, and only under certain exceptions do the courts apply the business days method, but that's not very often. So keep in mind, where every time there's days mentioned, the number of days, 20 days or 30 days or whatever it is, it's being calculated on calendar days. And the day that you're served is not the first day, it's the following day is the first day. Okay, so day one is 0, where you get delivered. That knock on the door is day 0, but the following day is the first day. Okay.
And so once you get that, knowing there's going to be a lawsuit, knowing that there's a lawsuit filed, again, as I mentioned before, there's this whole issue of spoliation of evidence. And that is where someone walks in and they go in, let's say a physician wants to, I need to change the record. And they start changing things around. And especially if it's a government complaint, that can lead to potential criminal activity if that record's changed. Once that, knowing that there's a lawsuit and you're trying to change the evidence that goes before that'll end up going before the court. So it's so important to have locked down the record. Now, if someone wants to make comments about the record, add it in. You can make comments about the record afterwards, yes. But the actual record that was in place needs to get locked down.
Yeah.
So it's not changed.
That makes sense. Fred, you were going to say something? No, okay, good, good, okay. Now, before you get started with the strategy for the lawsuit, you've got to really walk through your best case scenario and your worst case scenarios. You've got to really figure out how you would navigate those channels. You've got to also figure out what the nuisance value is, not only to you or to them on the opposing side, and even to the other co-defendants that may be on that lawsuit. So you got to think through those scenarios, and you got to really like diagram it out for yourself. And that's really the intent of that illustration there, is just graph out what are your options. If this happens, then what do you do? If that happens, then what do you do? Some attorneys and some folks literally have a strategy to stall or to accelerate. And I've seen that used too. I've used it myself. And that's a very real reality of litigation. It's the way you get to the other side so you can maximize your outcome. Here are some do's and don'ts after there is a receipt of legal papers, right? So you get a letter of intent to sue, right? Or you get a complaint. What do you do next, right? So what do you do next? If you're in a corporate environment, what you're going to do is you're going to talk to your risk management folks, okay? If you are independent, if you're an independent practitioner, then what you're going to do is you're going to contact your insurance company or the agent to your insurance company and forward them what you received. And when you forward it to them, send it to them and ask them for a confirmation back. Chances are you're going to email it to them. You're not going to hard mail it, but you can hard mail it. If you hard mail it, make sure you ask for a return receipt certified. If you email it to them, call up the person and say, hey, can you confirm that you got it? Please put it in writing back to me so I can rest assured that you've got it. And they will do that. I've actually seen cases where the individual turned over the complaint to the insurance company, and the insurance company dropped the ball, and it was a default judgment for like $300,000 against someone. And then they had to go back in and reopen the case and blah, blah, blah. Now, we were able to reopen the case, but it took a doing. $300,000 was real money. So, so the insurance company was on the hook. They had to pay for all that sort of stuff. But keep in mind, these kinds of things happen. Make sure you get return receipts. Now, some folks are actually self-insured, so they have to go out and hire their own attorney. And for that, there's actually, there's even some law firms that specialize in it. I just have a hard time understanding that business model, frankly, but anyway, it's out there. Now, do keep in mind, if you have an insurance company, you are entitled to legal counsel from them. So they have an insurance company has a duty to defend. When they have a duty to defend, they will get you legal counsel, but it'll be a legal counsel that they will choose. If it is not an attorney that you chose, they're the ones that are choosing it. And chances are they'll be the ones to initiate that whole thing, right? So what I would suggest to you is to go and get personal legal counsel. Even though your insurance company has picked somebody up, get a secondary counsel on the back to kind of help manage the process. And you'll see why. We'll talk about this in a minute. Once you get that complaint, you're going to have to actually put in your calendar when the 20 days are up, right? When the 20 days are coming, because you don't want to leave this thing to chance. So what you do is you mark your calendar. You keep track of what's going on with these deadlines and papers, and you got to keep that whole library kind of sorted out for yourself. And that's why I suggest getting a personal counsel, because a personal counsel will help you go through that process, but they'll take the headache away of managing it. For those who have been in lawsuits or medical malpractice lawsuits, they'll tell you they've been in it for years and years. And they don't know what to ask for next from their insurance legal counsel. So what will happen is that your personal counsel will help you make sure that your insurance counsel is doing what they need to do and coordinate for you. If not, it's literally like minimal dollars, but it's a huge second policy on the same thing that's going on. And remember, your license is on the line. There's a livelihood issue there, right? So you got to make sure that your license is the most important. You can take pretty much anything away from me. You can take away my car, you can take away my house, you can take away even my bank account. But if you take away my license to practice, I don't know what happens to me tomorrow, frankly. You know, and in the same way, I think a lot of physicians have the same thing, right? It's the same sort of a fear, and it's a very real fear. So keep that in mind. Having a second counsel is really not a bad idea.
Very good.
The
How you
personal
doing?
counsel, I'm sorry.
What's that?
The personal counsel will help get you extracted out of the
Yeah,
lawsuits
this is broke
if it
over
was
here.
ever possible.
This one is.
Hey, and one thing I want to mention too, is on
Doesn't-
this 20 days and these timelines,
Mhm.
is that a really good day if someone's filing a lawsuit, filing the complaint, is the when we're giving the seminar in early November right now, mid-November. The good day for them to file it is that Wednesday before Thanksgiving, because everyone's taken off Wednesday. So that's Wednesday, Thursday, Friday, Saturday, Sunday. 5 days taken off that 20 days. That's that potential litigant is going to try to take an advantage of.
Yeah.
And I have seen it. I have seen that Wednesday things coming through that Wednesday, especially right at the end of the day.
Yeah, and
Or if they know you're taking on vacation, if you know you're going out on a vacation, them trying to use that to start it off. So, I mean, I was just involved in a very large business transaction, and the attorney on the other side was very, very large. And the attorney on the other side, had a vacation coming up where they were actually booked to go to Europe the day after the set closing date. They never told me that. I would never, literally would not have taken advantage of that, most likely because he is being cautious of the other side knowing when someone's not going to be around to attempt to use that knowledge to manipulate timelines. So that's just something always to keep in mind, that someone knowing you're going to be out when you know there's going to be litigation coming through, that
And
they might use that.
using that timeline to your advantage is a real tactic. It's a real tactic in litigation. So I think that's a really good point, Ed. So then what happens? So now this lawsuit that a person's been served with, there's going to be really four components to this. And for all of us, including Fred, that are attorneys on the line, there's actually four components to a negligence claim. One is duty, one is breach, one is cause, and one is harm. But what is duty, right? So it's the physician owes a duty of care. That's really the standard of care is what they're referring to. And then how did the physician, which is going to be now the breach part, how did the physician fall below that standard of care when they didn't follow it, right? And then was that breach the cause of the harm, right? So it caused the harm, that it was foreseeable that injury would have occurred. And the harm is usually translated to money. So what's going to happen is that the plaintiff has to prove these four parts, but you as a defendant only have to knock out one of them. You don't have to, you don't have to knock out all four. You just got to knock out one. It's literally like a four-legged table. If you take out one of the rectangular table, if you take out one of the legs, it's literally going to fall down. So you got to make sure that one of these legs gets knocked out.
And the one way, again, getting back to the very topic what we're talking about is bedside, manners, is the bedside. That's where the facts can be generated. Many of the facts can be generated that can be used in the defense, or to knock out some of these elements early on in that physician-patient interaction. So the more, the more information, because as lawyers, we have two pieces. We have the facts and we have the law. What are the facts? What are the law that applies? So it's the facts, which are the client is able to obtain or have or generate initially early on. So keeping that in the bedside, that interaction, having those communications, making sure the records are well documented, that information that's there, eliciting from the patient early on issues, so what that the patient is telling you everything. When maybe you have a case down the line where the patient's prejudiced by not having given you some information that's necessary. So you also make sure that really ties that back.
The other thing to keep in mind is if a patient during bedside manners, if a patient was ever complaining, make sure that those complaints get documented and explained in the documentation, right? So if somebody says, hey, I'm going to sue you because you didn't give me an appointment, I would note it in there. I would note it into the system saying that the physician threatened today with a complaint regarding not able to accommodate seeing them. And they had unrealistic expectations because they only called us up this morning and they wanted to be seen today. It's just, in most physician practices, that's usually not possible. And if you did accommodate them, let's say that same day, and you saw them, then you actually say, and we took care of it. We saw them the same day. So I would actually document things like that, because you know that those are your trouble spots. Those are your troubled individuals that are going to come back at you. So I would record it. I think it makes good sense to be able to show that in the file, that the person was already kind of thinking this way, and we did everything we possibly could to make it all right for them. I mean, they still weren't happy. So now, there's also what's called comparative negligence in law, and that's usually another defense that's given. So, for instance, if there is medication, a physician prescribes, let's say, 5 milligrams of something to a particular patient, but the patient turns around and takes 50 milligrams. So it was the right medication, but the patient took the wrong dosage, right? So when they take the wrong dosage, whose fault is that? So, comparative negligence is another thing that you're gonna want to look at as you're reviewing these sorts of lawsuits, is who else is potentially responsible for whatever you're being blamed for. So, with that said, here's some of the key steps that occur in a lawsuit. You're gonna get the first set of demand letters. It's gonna be either one demand letter or two demand letters. Then it's gonna be followed by a complaint, which will then give you about 20 days to actually respond to them. Then you're going to file your answer and affirmative defenses. You got to raise all of your affirmative defenses. And that's why I say bring in a second counsel, because if you don't raise your affirmative defenses up front, they're deemed to have been waived. So you got to raise all of your affirmative defenses. So what I literally do is I throw in everything in the kitchen sink into my affirmative defenses, even the ones that are just basically plausible and and aren't necessarily my strongest points. But instead of offering them 5 affirmative defenses, I'll usually have like 15 affirmative defenses. So I go at those affirmative defenses in a very sort of a strong way. The next thing that you're going to have is there's going to be discovery that takes place. That's when they'll ask you for records, depositions, questions and answers. There's going to be a lot of that sort of stuff. And if somebody doesn't respond, you can always do a motion to compel. You can even do a motion to compel on the plaintiff, right? You can ask them for their records. You can ask them for questions. And you can even depose them. So if a plaintiff ever sues you, you can ask them a lot of questions and you can put them on the stand. Next, what will happen is parties will often move for like what's called a motion for summary judgment, and simultaneous to that, there'll also be a mediation. And do remember this: a majority of the cases, 90% plus, are settled in mediation, or there's some sort of a settlement that happens. Very few go to a bench or a jury trial afterwards. But the settlement, you got to be super, super, super careful about. And I'll hit that on the next slide. So at this stage, what I want you to make note of is 3 things. One is, as soon as you get a lawsuit, you make a copy of the patient file. Keep that for your record, so you've got a complete file and you can easily refer to it. Mark on your calendar the key dates that are occurring, and get a personal legal counsel to actually help guide the whole process through. Remember, it's a fractional charge compared to what the insurance company is going to pay for on the other side. So now the possible outcomes that can happen in a lawsuit are there could be a voluntary dismissal, which never happens voluntarily, frankly. You got to push it. You got to literally beat them and thumb them down into it. Or there could be a dismissal. There could be a dismissal with prejudice or without prejudice. With prejudice means that the plaintiff can never raise it again. Without prejudice means that they can come right back at you. So there's that. But and then there's a possibility of a summary judgment. A summary judgment can actually be in 2 parts. You could have summary judgment as to liability, and you could have summary judgment as to the amount of damages. Those are 2 different things. So a lot of times, what I'll do is I'll move for partial summary judgment as to the issues of liability. And if you win that side of it, the case is over. The case is over, guys. So you want to do that sort of stuff. You also want to keep in mind that in mediation, there is often a settlement. But if a settlement happens, keep in mind, if your name is on that settlement agreement and you're a party to that settlement agreement for having settled out for any sort of a monetary payment, that it is a reportable item to the state Department of Health and to the National Provider Data Bank. So a lot of physicians do not realize this. This bullet point right here that says important, that's the one thing a lot of physicians don't get, is that if there is a professional malpractice negligence lawsuit, that and there's a payment on behalf of a physician that's a named party to that settlement agreement, it's got to get reported. And once it gets reported, guess what? All the future employers are picking that up. And now it's going to turn into a real thorn in that physician's side. So the way you settle this is you got to get your name out of the lawsuit. And that's the only time you actually settle. So the way we do it is we make sure that our physicians are not named in the actual settlement agreement, that they're literally extracted out of there, that the business actually does the settlement, not the physicians. So keep that in mind. And that's a huge, huge issue. And we help people through that. The other thing is, you might ask, how long does a lawsuit take? So on TV, it takes an hour, right? But a lot of people think it's over in like 3 months, 6 months. What could take all that long? Well, frankly, majority of the lawsuits take about 1.25 years. So this right here is a timeline of what's the fastest a lawsuit can travel. And it's close to 2 years, guys. So if there's going to be a lawsuit and people are going to fight over it, it's going to take at a minimum of like, literally it starts on that May 01 to December 02, right? Because prior to that is all like a different shade, and that's all of your demand letters. But once a lawsuit begins, it's easily, what is that, roughly 20 months right there. And that's the fastest it'll move. So, you got to give it 2.5 years, basically. There's no way, it would be unrealistic to expect a lawsuit to be over in less than 2 years. So that's why you got to be in it for the long haul. You got to pack a lunch. You got to keep a calendar. You got to keep copies, and you got to get all the help you can, because what's going to happen is it keeps physicians up at night. And this is why, that's also near and dear to our heart, because that's the one pain we know we can help them with, and we'll take care of it. So do keep in mind there's people out there that can help you. It doesn't have to be us. It could be somebody else as well. Please, go with who you feel comfortable with. But we know what it takes. Like this part right here, where we talk about not getting named with the Department of Health and the National Provider Data Bank. Majority of the attorneys out there do not know that. Can you believe that? Including the plaintiff's attorneys. They don't know that, and they don't understand that concept as to how tight these reporting requirements are for physicians. So with that said, it's a long battle if bedside manners go awry, but it's certainly you can overcome it. And if you have any questions, we're happy to help you. If you have any questions at this time that you don't mind speaking about on a Zoom video, feel free to ask those questions now. Any questions, guys?
Well,
thank you.
Ben,
So if you
that
do
was
need
excellent. That was excellent, Ben. So we'll go ahead and tell people how they can get a hold of you should they just want to talk some more. Just kind of like
Yeah, so
maybe have some different facts that they don't want to bring up here and just want to kind of bend your ear a little bit.
So if you have a cell phone handy with you, just take a picture of this last slide. It has all of our contact information on it. For example, you can call me on my cell phone, which is 954-445-5503. And that's my cell phone. I take phone calls and texts, and we all do, frankly. And the business is such today, and really that's the better way to operate with your clients. And if you want to email me, my email is BAM as in BAM at mirzahealthlaw.com. So take a picture of that if you want to get a hold of us. Otherwise, you're welcome to go to our website, which is mirzahealthlaw.com. And there's a bunch of stuff there. But if you need any of these slides or whatever, let us know, email us, and we'll happily email you this slide deck. So you not only have it for yourself, but also for your office staff as to what to do next.
And what I'll wind up doing in the next couple of days is actually, this presentation will be uplinked to YouTube on the YouTube channel, the South Florida Hospital YouTube channel. And you'll get a link to that in a thank you for signing up for this seminar. And also we'll give you, I guess, a copy of the slide deck. Ben, is that okay?
Yeah, that's definitely okay.
Yeah, we'll send you a copy of the slide deck, and Ben will communicate with you that. He has a list of people. I'll send him the list. He can send you the slide deck, and I will go ahead and send you the link to the video, which will also be on my website and in my emails.
And before we go, I do want to thank South Florida Hospital News for hosting these seminars. So appreciate it.
Absolutely. Thank you very much, Charles.
My pleasure. I'm going to stop the recording now.